is Jessica Simor QC, barrister and the specialist in regulatory and EU law. Jessica, thanks for coming in. We try and unpick this a little. First of all, what was your reaction when you heard this ruling?
Well, I was very pleased that the court has actually stood up and said that the role of Parliament is to scrutinise the government, and if the government closes down Parliament to stop that scrutiny, it will declare that unlawful.
Because they were overturning a previous ruling. So did that come as a surprise, given the basis on which they did that, or not?
It's a brave decision.
Right.
It's a brave decision because it's a brave thing to do, but in a way it's not surprising because the power to prorogue is a power to suspend Parliament to hold a new Queen's speech for a new legislative programme, and that usually is for a period of, say, 4 or 5 days. What has happened here is that the government has suspended Parliament for 5 weeks, having previously threatened to do that, to stop Parliament scrutinising Brexit, but then saying in front of the court it wasn't doing that, it was for a Queen's speech. Yeah. And the court basically didn't buy that line.
Can we help viewers understand the difference here? Because Sarah referred to the High Court in England and Wales, which made its own ruling in a separate case brought by Gina Miller and others, and decided that this was not within the remit of the court, that it was a political issue, essentially. So what are viewers to make of the fact that we have another court in the UK deciding it's very much within its remit to decide on this?
Yes, well, in fact, at the High Court level, both in Scotland and in England, the courts found this was not within the remit of the court. It's the appeal court in Scotland that found differently. That said, the English court had the 3 highest judges in the land in it, sitting as a divisional court. So we've got an imbalance. That said, when the Supreme Court comes to hear this, it will be dealing with a finding of fact by the Scottish Appeal Court, the highest court in Scotland, that the government misled the Queen and prorogued on a false basis. That is a finding of fact. Now, in usual legal proceedings, the appeal courts don't look at findings of fact. They're bound by the lower court. So it's got a High Court decision in England saying it's not justiciable, but it's got a finding of fact in the Court of Appeal in Scotland saying that actually the basis of prorogation was a misuse of powers. So the Supreme Court would effectively have to say that whatever the abuse of power, it cannot look at this kind of prorogation or prorogation.
Right.
And that would be a very dangerous precedent to set.
Why?
Well, it would mean effectively that the government could go to the Queen on any false basis, could not tell the truth to the Queen about why they were proroguing, could do it, for example, when legislation was going through that they didn't like. For example, the legislation we had last week. Government could go to the Queen and say, we want to prorogue for a new Queen's speech. And the courts couldn't look at that.
So I'm assuming that lots of viewers will now be saying, well, OK, are you trying to say to us that the Supreme Court will go in a certain direction next week or not?
No, I mean, I wouldn't make any judgment. Right. It seems to me the Supreme Court is in a difficult situation. It's either going to have to say that the highest court in Scotland got the facts wrong, i.e. it's willing to consider the facts and they got them wrong, which is quite a difficult thing for it to do, or it's going to say they got them right, but despite that it's not justiciable, or it follows the Scottish court and holds this was unlawful.
Stakes are incredibly high, aren't they?
Incredibly high.
Yeah. One final point, which is the information which the Supreme Court will want to see as part of its consideration, because we've heard lots of demands for communications details, for example, between advisors and others in relation to the decision on proroguing Parliament. Will that automatically follow? Will the Supreme Court be able to order the delivery of that information or not?
Well, in public law proceedings, the government is under what's called a duty of candour to disclose all relevant documents, telephone messages, whatever, relevant to its decision so that the court can scrutinise the legality of the decision. What is strange in this case is that there was no sworn affidavit by the government or by the government lawyers, which is usually the case, saying that this was the truth.
Right.
So there is an odd situation, and that led to Dominic Grieve bringing his humble address on Monday, saying, I think he used the word, there seems to be a scandal, I think he used the word scandal, and he sought all documents, and that's a very unusual situation, and the question arises as to whether the government will comply with a humble address before the Supreme Court hearing on Tuesday.
Right, so plenty for us to think about in the meantime. Jessica, it's very good to talk to you, and thanks for
Thank you.
shedding light on it. It's very
Thank
kind
you.
of you. Thank you. Jessica.